the hearing on the zoning application for granting materials. This is a continuation of the hearing that was previously conducted in this matter. I am Kevin Convoy. I'm the solicitor for Ransom Township. I have been appointed as the hearing officer, which means I can be the one that's running the hearing. We're going to have Jim Murphy from the Planning Commission give his report and report on the Planning Commission's recommendation. Then we will have the applicant present their application, calling witnesses that they wish to call. Then we'll hear from the objectors. After the applicant has closed their case, the objectors have a total of 100 days in which to present their case. Is there anybody who was here, was either not here, or was here who did not sign up and wishes to sign up as an objector? Please come forward. I did receive today Laura McGarry, who's here in the front row, submitted the withdrawal of her party status application and then entered her appearance as an attorney for objector Susan Magnata. So we'll accept that. At this time, I would call James Murphy from...
Mr. Convoy, I'd like to object on two bases to the hearing. First, to...
State your name.
Sure. Laura McGarry, as stated, I am here on behalf of Susan Magnata. She's a homeowner and resident of the Fawnwood Heights neighborhood. My first objection is as to the notice for this hearing. Pursuant to, from what I understand, and that's part of my second objection, is this is a request for an amendment to the zoning ordinance. The notices that were just entered into evidence as part of this proceeding did not contain such an inclusion of the text or reference to where the text would be made available. And on that basis, my objection is that this hearing was not adequately noticed to the public.
We assume materials have nothing to do with them.
If there's a change to the zoning ordinance, you may be correct, but for the hearing tonight, I think that the notices are appropriate under the requirements of the zoning ordinance of Ransom Township.
So I think my follow-up to that would be then to get specific clarification on the nature of this hearing and under what provisions of the MPC or the local zoning ordinance we're proceeding if the understood outcome is that this isn't going to result in an amendment. What are you here for then?
So at this point, we're not at a point where we are amending. We're hearing their application. There'll be a decision made, and at that point, the zoning, the appropriate advertising would be set forth following, and there'd be a public vote on the amendment.
I am concerned that the nature of this hearing could be perceived upon appeal as being the type of hearing that would result in an amendment should the applicant pursue that avenue on appeal.
And they've indicated they're in agreement with the procedure that I've outlined.
We agree that we're going to follow whatever procedure comes next pursuant to the board, the MPC, and the township.
As long as that's on the record, I'm satisfied.
Okay.
And I want to clarify that both the MPC and the Ransom Township zoning ordinance define public hearing as a defined term. And I don't know that there is necessarily a distinction between a public hearing and a public meeting. But if that process is going to be followed, then
That's what they've indicated, and that objection will
be withdrawn.
Okay. What were the findings of the Planning Commission with regard to the proposed zoning overlay district?
We were at that meeting. We were presented a concept plan dated 12/12/2025. On that drawing, there were 6 buildings proposed. They're 214 foot by 732 foot per scale of the drawing, with 120 foot maximum height per yards. Buildings appear to be about 250 foot in elevation between the lower 2 buildings and the upper 3 buildings. The upper 3 buildings to the last building appear to be another 100 foot elevation going uphill per retaining wall max height and spacing per your drawings. There's an SWF, stormwater management pond. It's about 446,500 square feet, meaning it's about 250 feet wide, about 893 feet long against a 50-foot retaining wall. Second stormwater management pond is about 737,697 square feet. It's against two 50-foot retaining walls. Usually these are a minimum of 2 foot thick as well. Both stormwater management ponds will contain probably at a 2 foot depth around 8 million gallons of water on top of it. Drawing shows retaining walls 50 feet in height within 70 feet of the property lines. The drawing shows additional properties, all adjoining properties, but no references to owners or size. The drawing references cooling towers. There's nothing on the drawings. These are noise producers. The drawing references wetlands. Again, there's nothing on the drawing indicating any of that. We read through the ordinance proposal and 406.1 data center overlay. Number 1, 120 acres that do not encroach or disturb, infringe on any wetland or waterways shall also be free of protected and endangered species habitat. It's not in there. The 120-foot height, does that conflict with airspace and fire companies for emergency services? Page 4, numbers 4, 5, and 6. Minimum setbacks, max building coverage, and max impervious coverage. Review these against other commercial industrial zoning rules. They don't seem to be in line with any. Architectural design guidelines, page 4. Notice solar structures on the roof. This will make the buildings even taller. Even if the data center runs on public water and sewer feasibility analysis should be performed consistent with requirements for non-public water and sewer facilities. Number 8, standards requirements in Pennsylvania DEP plus all other regulatory agencies having jurisdiction, including but not limited to the U.S. Army Corps of Engineers, the Chesapeake Bay Commission, etc. Provide estimated power consumption and feasibility study with a letter of authorization. The ordinance does not include environmental and community analysis with impact assessments. Example, water, sewage, solid waste, emergency responders, etc. Those are the things that we kind of read into this, and that's the reason why we kind of said that we don't recommend it.
And the concerns that the planning commission had regarding the plan that was submitted, if the ordinance as authored by the applicant were to be granted, would any of those concerns be covered by the proposed ordinance?
Not really.
And ultimately, based on that, what was the ultimate recommendation of the planning commission?
The ultimate recommendation with the planning commission was that they do not accept this ordinance as written.
Just make sure you're in the microphone.
So what I'm going to provide Mr. Murphy is our exhibits 1 through 8 for him to reference. Ransom Township zoning ordinance.
Okay.
In that ordinance, would you agree with me that it does not provide the data centers as a use? Is that correct?
I'm sure it does, because when this was done in 2008, the centers were bought.
So it does not. I just want to make sure I heard you. It does not.
Correct.
Okay.
You heard what I said, yes.
And in there, there's no other reference of anything synonymous with data centers or anything to that effect, correct?
I object to this line of questioning. I understand the rules of hearsay don't apply strictly. However, this is a document, it's a public document that I believe can speak for itself. And I don't know what, respectfully, this gentleman's knowledge or qualifications are with respect to comprehensive understanding of every provision of the local zoning ordinance.
Do you want to move for the admission of the zoning ordinance?
Yes.
Okay. Any objection to admission of the zoning ordinance as an exhibit from any of the objectors?
No.
Or it says here, current zoning ordinance does not provide for data centers as a use.
And then within that application, it identifies the proposed zoning change in the overlay, correct?
Correct.
Well, that's not one of the exhibits.
No, it's not. How come?
I appreciate what you played it.
You have to,
Can he answer the question?
you have to just answer his question. Thank you.
Go ahead. What's the question?
I want to just be clear. You nor any of the other members of the planning commission nor the solicitor provided any written comment back to strand materials, correct?
No, we did not make any recommendations. We asked a lot of questions as to various first.
That's not the question I asked. Could you just, as Attorney John said, could you just please answer the question? I'm trying to give you some latitude, but you continue to put comment in. I'm asking a simple question.
No, we did not.
Okay, thank you. So then basically, just so we're clear, the township's exhibit 6, this is all of us. There's no other emails, texts, phone calls, and anything from any member of the planning commission to anyone on the board, to the solicitor, nothing like that? That would not be privileged.
Objection, there's a question with, no, and I'm not entirely sure.
I don't know if it was a
I
question.
object to the form if it is a question.
What was, if you could re-ask that question.
There is no other documents that were prepared, that were submitted, that are not in the record today, that were submitted by you or any other member of the planning commission to members of the township.
No.
The proposed amendment was brought before the planning commission, and we had those two hearings that Mr. Sullivan discussed, correct?
Yeah.
Can you say yes or no on the record?
Yes.
Okay. After that, the recommendation was transmitted by way of the meeting minutes to the township, correct?
Right.
As far as you're aware, there's no other obligations under the municipality's planning code or the Ransom Township zoning ordinance for the planning commission to take any additional action, correct?
Right. We're only a recommending body. We recommend they bring to us, we go through it, and we recommend changes, additions, subtractions, and we recommend the board what they should do with it.
And you did that here, correct?
We certainly did our job, yes.
Nothing further.
Do we have any other attorneys in the audience that are representing any of the objectors? Okay, I see no hands. Do we have any objectors that wish to ask questions of Mr. Murphy? Cross-examination. Okay, sir, if you raise your hand, come on up. Get in line. Just so you're aware, when you're coming up to ask questions of any witness tonight, you are asking questions. This is not the time for you to provide public comment. That will come later.
So I understand
Yes.
your place, or the planning commission's place, is to make your best judgment as to whether to approve something or not approve.
Right. We make sure that it meets the rules, the regulations, as best it does. I mean, it's basically, we review it, the township engineer goes through it, makes recommendations. We make recommendations, it gets changed, amended, then we approve it or disapprove it at that point in time. We only recommend to the board of supervisors if they should accept it or not accept it. So the building is 100 feet?
150 feet.
Yeah, you got it.
So I could have
You could have way more
a
buildings.
building, 2 football fields in size, 150 feet from my property. Okay.
Yes.
Were all your questions answered so that you can make a very clear, informed report?
I just make an objection to the question. As far as this gentleman could talk about whether or not he felt that his questions were answered, but I don't believe he could testify as to whether the public felt their questions were answered.
I don't feel my questions being answered. Was the question asked about the wildlife and what was going to happen to the wildlife in that area?
I recall that question was asked.
And the answer to that question was?
The answer to that question from Mr. May was, my recollection is correct, that there is no wildlife there.
Were you paying attention to what my answer was at that meeting?
Yes.
What was my answer?
Your answer is that you don't have enough information. We have wildlife, and we don't have the answers. And we're supposed to make a case, and you're going to decide on this case tonight. We don't have the answer that we need.
And again, ma'am, if you have questions for Mr. Murphy, that's your opportunity. Well, thank you.
If everything in this doesn't follow the ordinances correctly, the planning commission can still
That's
vote no.
objection, speculation.
Yeah, and I'm going to grant that objection. He can't comment on what would be, on something else that would be submitted. That's not before the planning commission at this point. Okay? Thank you.
I think what he's asking is, does the planning
Okay.
commission, you're not, I understand that, but I'm just
You can't comment.
I did tell you that the lower buildings to the upper buildings as proposed on their concept drawing that was presented to us in January, the elevation changes between the two of them are very concerning.
And because the general public was not privy to the concept drawings, was there any presentation to the planning commission why it is required or needed that the data center be exempt from the steep slope provision?
No.
Okay.
Mr. Sola, the floor is yours. Or Mr. John, I'm sorry. I'm not sure.
No, that's fine. At this time, we would move for the admission of exhibits 1 through 8 previously provided at the prior meeting as on behalf of the moving parties.
Any objection to exhibits 1 through 8?
I object to those exhibits, first on the basis that none of the parties in this room have had the opportunity to review these exhibits. I secondarily object, without having the opportunity to review them, on the lack of authenticity. I don't think Mr. Murphy is in a position to authenticate the exhibits. I haven't seen them, I don't know what they are. To authenticate exhibits, maps, drawings that were prepared by someone other than Mr. Murphy, except to the extent that he can authenticate that it is what he reviewed, not that they purport to say what they're saying.
Any other objections? Okay. The rules of evidence today do not apply under the municipal planning code, so I would recommend that that objection be overruled and the exhibits be admitted.
No.
Okay, we have to have order. Okay, the objections are overruled, exhibits 1 through 8 are admitted into the record.
Will there be an opportunity for the parties to review the exhibits prior to pretty much anything else happening that would require possibly evidence or cross-examination?
Are you requesting that they be provided now?
I don't know what's about to happen. I don't know what witnesses that the applicant is putting on. To the extent that they're going to be questioned about these exhibits, my cross-examination would be based on my understanding in a review.
We're not presenting any witnesses.
There's no witnesses being presented.
No, sir.
Other than the submission of the exhibits, do you have any additional evidence?
In that case, then I understand that the rules of evidence don't apply here, but this is a proceeding. As a quasi-judicial body, the burden of proof is on applicants to do whatever it is that needs to happen at this hearing for the board to vote. I move then for what is essentially a non-suit on the basis that they've provided no testimony or evidence or no information under oath to substantiate the basis of the application. And I request that the board vote on this now on the basis that they have not, on this non-suit basis, presented anything that would substantiate the nature of the request here. There's been nothing presented for the board to consider at this point.
So, he authenticated those documents because they were submitted in 2 prior meetings.
And when they were submitted, Attorney May was present to answer questions, and the application speaks for itself.
And the documents that supported the zoning overlay map, the zoning overlay, all those documents speak for themselves. That's the decision that's being made on those documents.
To the extent that the Planning Commission considered any documents, that's it, although a provision that they needed to hold that Planning Commission hearing, that's wholly separate and apart from what's happening tonight. This is a hearing. The burden is on the applicant to present evidence and testimony sworn under oath, to authenticate their evidence, and to establish the basis for which they seek relief. They have put nothing on other than to ask questions of Mr. Murphy, who, I renew my objection, cannot authenticate those exhibits for what they purport. Certainly he can say they are what was presented to him. He cannot confirm that they adequately represent whatever is conveyed in those documents. Again, have not seen them, don't know what they are. But this is a hearing. Nothing's been heard. They haven't presented any evidence. I think that there's sufficient basis for the board to deny the application without the need for any other testimony or evidence. I don't even know what the testimony and evidence would be in opposition to because nothing's been presented at this point other than some paper, which I continue to argue can't be authenticated.
How does she want us to authenticate our submission? We've submitted an application. It's submitted by us.
Call a fact witness. It's a hearing. Call a fact witness to testify as to the document.
We're submitting it. That's our authentication.
And also,
Submitted as part of the record.
and also the documents have been accepted into the record. So the documents are accepted into the record, and the Board of Supervisors
Then can I cross-examine these attorneys? Are they going to be fact witnesses for the purpose of me questioning now exhibits that have been admitted into the record that have not had any cross-examination on them? I believe the rules of professional conduct would prohibit either of these attorneys acting as fact witnesses here. They haven't presented any.
And we've already testified there are no fact witnesses.
I don't think they've met their burden, and I think that's sufficient for the board to deny.
Mr. Chair, I think the simple question is, who would be questioned about those documents?
I understand the question. I think this is something that requires more research than we have the ability to perform as we sit here right now. We'll take your objection under advisement, and
Mr. Conover, the only thing I would ask then is, we're going to go that way, and then I would just ask that the record be held open. And if it is determined after you've conducted the research that we need additional witnesses to be present.
So we can
Yes, we all want to hear
All right, so I would recommend that the record be held open, and if you determine that additional witnesses are needed for additional authentication based on her objection, that we be permitted to return with the appropriate witnesses that you deem are necessary to complete the record.
I'd object to that being wholly inappropriate. They've had the opportunity. This meeting was called in a speedy fashion pursuant to their statements that they were going to follow the 60 days. The meeting was held. They had an opportunity to bring whatever witnesses they needed to put their case on. They didn't bring anybody tonight. You don't get a second bite at the apple because the quasi-judicial body says you didn't do enough.
But
This was our opportunity to
nobody
be
said we
heard.
haven't done enough. You indicated you need to do more research, and if that's necessary based on her objection, which we not anticipated her objection prior to coming here tonight, then we will provide whatever additional evidence or testimony you require to complete your evaluation. And the documents have been submitted into evidence.
If that's the case, if they haven't rested their case, then I'm ready to withdraw my objection and allow them to call their witnesses, and when they don't, I will renew my objection because they don't have anybody here to testify.
You need to determine if you feel that, you said you need additional research to determine if witnesses are required beyond the documents that have been submitted as part of the record.
That's not the job of either the legislative body or a body sitting in a quasi-judicial capacity to provide legal guidance to counsel as to what they need to do to meet their burden of proof. That's up to them. If they haven't done it, they haven't done it. And that's why I would request that the board make a decision now on the basis that they haven't met their burden, it must be denied. I've never heard of a situation where an applicant or a party to a legal proceeding would ask for whether or not they've done enough and then be given the opportunity to come back and have a second chance at it.
If you listen to what he said based on your objection, he needed to conduct additional research to determine what's necessary. I'm not looking for guidance. He's trying to rule on your objection.
If the research is on the legal basis of whether or not my objection can be entertained by this board, the legal research, I'd argue, is unnecessary, but whatever, then so be it. However, the research shouldn't be on whether or not they've met their burden, and if they haven't, leaving the record open for an opportunity to do it again. Again, I will withdraw the objection right now, let them present the remainder of their case in chief if they haven't rested, and when they rest, I will be prepared to make this objection in probably a few minutes. I'm prepared to do that.
Here's what I'm going to do. I'm going to close the record briefly while I go into the other room by myself to review the requirements in the municipal code. And then I'll come back and make a recommendation. Okay?
For the first time ever, What is your opinion on all this?
Right now, my opinion is that, I think data centers have their place, but this isn't the place right now in a residential area where people want to have, their own privacy and their own well-being and way of life to themselves. So, let the people speak, and whatever they say, this is where they live, and if they don't want a data center there, they shouldn't have one. We're just actually getting educated ourselves as to what's going on, water consumption, environment, what it does to the environment. It's a budding industry, so it's kind of hard. I don't think data centers belong in residential areas. In industrial areas is a different topic. I'll never support any bill that takes away local support and the local governing bodies from making those decisions. So Senate Bill 939, I think Senator Rothman's bill, it's a data center bill that the governor supports, that when the devil in the details came out and they rolled out the language on the bill, it showed that there's a zoning part of the bill that takes away local control, and I have an amendment that I'm going to put into that to change that and make sure that local control isn't taken away. And I won't vote for the bill if the amendment's ruled out of order. I won't vote for the bill. Hopefully the maker of the bill will run my amendment. A lot of times in the Senate they're ruled out of order by the majority party, but if that happens, I'll vote no on the bill.
Okay, we'll go back on the record. All right, I've had the opportunity to review the Municipal Planning Code 53 PS Section 10908 concerns hearings before the board. It says the board shall conduct hearings and make decisions in accordance with the following requirements. Subsection 6 indicates formal rules of evidence shall not apply, but irrelevant, immaterial, or unduly repetitious evidence may be excluded. Given that, I am going to recommend that the supervisors deny the motion for a non-suit and that we move forward with the hearing. How do you rule?
I'm kind of with her on this. I mean, like when the solar people came to present their case, they had the environmental study done, they had the hearing study done, they had the glare study done, they had all the ducks were in a row, and they had professional people in that area to talk about it. I think they're going to present their application. They should present it with all the things that are required to come with it.
Okay, so how do you rule? Do you rule to grant the motion or to deny the motion?
I'll grant her motion.
Okay.
I agree. I grant the motion.
Grant the motion and the application is dismissed.
Yes.
Okay. The motion for a non-suit is granted. And I believe that essentially dismisses the application because they failed to submit the appropriate record. You had a comment to make.
Yes, Mr. Conboy. Just for purposes of the record, I'd just like to point out the fact that the items that are listed, exhibits 1 through 8, exhibits 3 and 5 are emails from you, which have been submitted as part of your record. 8 is the zoning ordinance, which stands on its own. So the proposed overlay ordinance, the application, the zoning overlay, the survey map, and the aerial map are the items that we attempted to submit as exhibits. These items were previously submitted to the Planning Commission pursuant to the directions by the township at 2 separate hearings. They were accepted, they were reviewed, and they were used as the basis for the Planning Commission to make its determination. The chairman of the Planning Commission, Mr. Murphy, was here. He testified that all the items 1 through 8 were previously presented and accepted into evidence at the Planning Commission meeting and were used as part of the determination that the Planning Commission, part of the factors that the Planning Commission used to make its recommendation. So based on the fact that these items have been previously submitted to a township board, they were accepted into evidence and they were used for purposes of determining the final outcome of the recommendation by the Planning Commission, and that Mr. Murphy testified that he was provided all these items, he authenticated that they were previously submitted to the Planning Commission, that they should be accepted here, and they should be used by the board to make its determination, just as it was used by the Planning Commission.
Okay, and that's noted for the record, but the decision's been made. Okay, that concludes the hearing. Thank you.
So tonight before the board was a hearing on a proposed zoning amendment. I objected because I didn't think that, one, that it was properly advertised, or two, that the form of the hearing was appropriate for the nature of the request. They overruled the objections, they proceeded with the hearing. The planning commissioner spoke, he was cross-examined a little bit, and then the applicant, or in this case Grant Materials, they had their opportunity to put on what they call the case in chief. They didn't put anything on. They admitted their evidence over my objection that no one authenticated it, but after that they didn't put anything on. So I objected on the basis that none of us even need to stand up and say anything in opposition to prove that they shouldn't get their application, because they haven't even proved that they should. And I asked the Board of Supervisors to make a decision that basically says, we don't need to hear anything else. We've heard enough to say that you are not entitled to the grant of this application for an amendment, and essentially denied and dismissed their application. That's the end of the ballgame. They're not getting their zoning amendment today. This is just the beginning of what is probably going to be a very long, probably legally complex process. And I think that's the whole point. I think that the expectation is that developers, landowners are going to come and ask for these uses in places that aren't going to stand up. And I mean, you saw this room tonight. It was full to capacity. There was standing room only. Obviously, people were here. And my biggest concern is you're asking for, in a data center, a very technical use of land. If you can't follow the rules of procedure and the rules of the zoning ordinance and municipalities planning code to file an application and follow that procedure, how can you be expected to follow the procedures and the safeguards that should be in place to prevent a detriment to people when these data centers are built? It doesn't add up for me. And I think the outcome tonight really stood for that. You need to follow the rules. You're not just going to get this by pushing it through. The Board of Supervisors are elected officials. It's the people in these rooms that elect them to these positions and trust that they'll make decisions on their behalf. The people need to show up to let their elected officials know what they want in their communities. And it's this type of participation that I think is probably most important for communities. Having a lawyer to stand up and make the legal objections, obviously important, but the pleas of the community as to what impact this is going to have on them, I think is very profound and very persuasive for the Board of Supervisors and whatever the governing board is in whatever municipality.